My Lords, I think then before the short adjournment, that essentially completed my submissions as to why we say, despite the fact that in these proceedings the originating process took the form of a motion supported by affidavit, nonetheless Rule 3.3 and indeed the other rules to which we've referred applied, and that's Rule 22 and then Paganiol. It seems to us then that logically the next question is whether the arrival on the scene of Maître Moutia makes any difference, and whether the court below ought to have found that that development meant that there had been substantial, albeit late, compliance.
Well, we read the submissions which were made, and they were accurate, weren't they? Page 99 at the foot. Counsel said, I will suspect it's only confirming as the applicant having signed the motion paper and as the applicant having signed the affidavit, which can't be what a lawyer is about, is the submission.
My Lord, entirely, and that's really, and that's our submission too. Can I just take you, in fairness though, to Mr. Hurnam, to the appellant, to the documents that were filed in relation to Maître Moutia?
Right, let's do that. Yeah.
Firstly, at page 63 of the record, there's what's referred to as a notice of appointment of attorney. Just, my Lords, to put this back into context, as my Lords will remember, there'd been a hearing in this matter on the 20th of June 2011 when the matter was stood over to pending the decision of the full bench. That decision was 1st of July, then another hearing on the 20th of July in this matter before Mrs. Justice Teelock, and she asked the appellant whether he might consider having an attorney appointed. And then this document was served on the Attorney General on the 26th of August 2011. And one sees that this document says that Maître Moutia has been appointed by the appellant.
Yeah.
And he says, I'm henceforth instructed to appear for the applicant in the above, who won't retain services of counsel, but will move for leave to appear in person. So that would appear back to be a reference back to section 12, and as well will seek permission to address the court in person. Right. And also says that when the matter was called on the 20th of June before Madam Justice Teelock, the respondent subjected to the motion put in by the applicant. I've now certified the motion paper, etc., as being true copies of the originals. And one sees an example of that, at least at page 68.
Well, 64 is good enough, isn't it? It's the reverse of this.
Yeah, 64 is the reverse of this, and that's...
But it's also certified as true copy.
Yes.
Yeah, so 68 is the one where he certifies the... Yes.
Yes, and one sees, as well, in contradistinction to this document, that Maître Moutia has signed at the top of page 64.
No, well, he hasn't. He's... Oh, I see. He signed it at the top. Yes.
Top left. Yes.
Yes, I see. Yes, I'm with you. Yeah.
And then a copy of the motion paper begins at page 66. And over on page 68, in contradistinction, what Maître Moutia has not done is to sign this document as his.
Yeah.
But rather, it's the previous document, as it were, Mr. Hurnam's document, but then certified as a true copy.
Yeah.
Well, that obviously is certifying these things as true copies doesn't take one any further at all. But the more relevant declaration of the attorney, presumably, is, I'm henceforth instructed to appear.
Yes.
So the question is that good enough?
Well, my Lord, in my submission, that's not good enough. It's part of the solution for the appellant, but the difficulty which was identified in relation to his case was that the originating process was non-compliant, because the document itself had to emanate from and be the work product of an attorney. Now, what Maître Moutia seems advisedly was not prepared to do was to essentially adopt that document as his own and say, as it were, I'll now lend my name to that document. All he did was to certify it as a true copy, which appears to be consistent with what the appellant said at the hearing in January 2012, when he said no attorney would sign the document. At that stage, Maître Moutier, as I understand it from one of the appellant's submissions, I think passed away in August 2012.
Yes.
So as at January 2012, he was still present and seemingly still instructed by the appellant and was acting as his attorney. But nonetheless, the appellant was saying no attorney will sign the originating process. So, although, my lord, I agree it's significant that Maître Moutier had agreed to act, and which is why I wanted to take my lords to the documents, to see that there was, as it were, that point. Nonetheless, the non-compliance which was later identified by the courts, we submit, had not been cured. And there's also the point that the courts below didn't advert to, but to which we refer, that Rule 5.2 requires any process to be drawn up and signed by the party's attorney.
Could there be, do you think, any circumstances in which an irregularly begun action drafted by a lay litigant or by someone who wasn't qualified on his behalf and subsequently adopted by an attorney could meet the rules, or would you have to start again? Well,
my lord, on those facts, no doubt the relevant party, relevant litigant, would have a powerful argument to the effect that although my proceedings were irregular when commenced, they've now been adopted, as it were, in toto by an attorney. And so, if you like, the presumed underlying rationale behind the rule has now been satisfied. Yeah. And that, no doubt, it could still be said against that party, well, the proceedings were irregular when commenced. And if it were clear that that had been done for some improper or nefarious reason, then the subsequent adoption might not cure the problem.
Is there a general power to dispense with strict compliance with the rules at the discretion of the courts?
No, there's not in the Supreme Court rules, my lord, no.
They obviously treat there as being because of the 1st of July.
Quite.
Well, my lord, absolutely, and it seems to me that the position is that if there's non-compliance with a rule, one is potentially in the territory of Rule 15, that the courts expressly iterated power at Rule 15 to order an action to be stayed or dismissed on the grounds of abuse of process, is potentially engaged. Or in any event, one's in the territory of the court's inherent jurisdiction to control its own procedure.
Yeah.
And then, of course, Mr. Casey, even if Maître Moutier could be regarded as having been appropriately positioned as an attorney throughout his, or from the beginning until his death, then there's the question of, well, he did sadly die.
Yes.
Now, could we quickly look at Hurnam against Ram Ghulam, which is in the appellant's bundle of authorities 1, number 12.
My lord, yes.
Have you got paragraph 5 of Judge Domar's judgment?
Yes.
As I stated in the above cited case, an attorney in our system of law has a continuing obligation in the case in which his services are retained. He's not a mere ignition key, designed merely to kick-start the process from its cold position and thereafter slip into hibernation. The role continues through the cases until its disposal and long after. It's a question of professional accountability to the court, the client, and the profession. Now, the first question is, you know, we stayed 3 other proposed appeals. Among the 3 stayed cases, is there a proposed appeal from this decision?
I would need to check that, my lord. I'm afraid I don't have the details of those three cases at my fingertips. But I can check
really, I'm wrestling with whether we can deal with the ignition key point in the judgment, or the judgment which will flow from today.
Yes, my lord, I understand. My lord, I can't give you an answer as I stand here now. It may be something that we can address in a short note after the hearing. I've seen, I think, a fraction of the papers in one of those cases, and I've not even seen papers in the others, so I'm afraid
Perhaps we're in a better position to research it than you are, Mr.
My lord, I wouldn't suggest that you undertake the burden. I'm happy to do it, but I can't, I'm afraid I can't give you an answer right now.
Very well.
I don't think it is, because we've got an order which contains details of 4 cases. That's Hurnam against the Attorney General and others, Hurnam against Haranji, Hurnam against Kumar, and Hurnam against Matadine and others.
Oh,
So it doesn't seem to be.
there's the answer.
Yes, it's not those.
So you would commend paragraph 5 to us?
My lord, we do, and it is one of the passages to which we draw attention as we're explaining the underlying rationale to the rules which commence with the rules which are under focus in this case, as it were, the rules that apply to originating process, and which explain or which give a rational explanation for the requirement that a party have an attorney from the outset and for some time thereafter. The decision of the Court of Appeal in Hurnam and the State, to which the appellant referred earlier, dealt with a case where an appeal had been commenced by Maître Moutia on behalf of the appellant, and then Maître Moutia had died. And the question was, what was the Court of Appeal to do in those circumstances when Mr. Hurnam had not sought to have another attorney appointed in his stead? And the Court of Appeal said that, this was my point, that as we're looking at some provisions of the Code de Procédure Civile, which remained applicable because they hadn't been ousted by anything in the Supreme Court Rules 2000, said that because the case was not en état by the time of Maître Moutia's death, it couldn't proceed, the appeal couldn't proceed without the attorney being substituted. We've sought to explain that in our short note on the Code de Procédure Civile at paragraph 5. My lord, it'll be one of these documents with a little
Yes,
blue
I'm sorry,
spine. No, I apologise for the number of loose documents.
Yes, here we are. Thank you.
En état means in shape, does it?
Means in shape, yes. So if one looks, we have provided in the short supplemental bundle the relevant provisions of the Code de Procédure Civile, and one sees they're to some extent echoed in the Supreme Court Rules 2000. So one has Article 61, which deals with exploit d'ajournement, which appears to be essentially a coordinate to the requirements of Rule 3 and so on, dealing with the originating process. And then a section dealing with the requirements of defences and subsequent pleadings. And then the concept of a case being en état, which may be referable back to the case in shape, heading just above Rule 22.
You still, after it's en état, you still require the leave under the Supreme Court rules of the court to appear in person.
Yes, you do.
Yes.
And you need another attorney, don't you?
You need another attorney.
The point is that it's not as it were, rendered ineffective ab initio by the death of the first.
Yes.
No, you don't need another attorney. I think isn't that what this is saying? That once it's en état, you
if the case
could
is
go
en
ahead.
état, and then the attorney dies after the case is en état,
Right.
which essentially I think one may take as meaning in the case of this appeal, if all relevant skeleton arguments and other documents to be placed before the court had been appropriately drawn up and filed, then the case was en état.
You could see, then Mr. Hurnam, as a barrister, while he was a barrister, could have appeared.
Yes.
Or the party with leave could have appeared.
Yes.
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 Without an attorney.
Without an attorney being instructed
The attorney
in...
would have done all their work.
Yes, got it.
Precisely.
Yeah.
Yes, precisely. So it's fair to say that the rules seem to concentrate on the attorney's role in relation to documents and the preparation of case documents, as opposed to having an attorney on the scene by the time of the final hearing. But, my Lord, yes, there is a point to be made that in the case of Maître Moutia, he had passed away in August 2012. That was prior, obviously, to the rendering of the judgment in this case. And so, to that extent at least, the problem that might have been cured by his having been appointed and having agreed to act as an attorney had resurfaced, although not a matter reverted to by the court below in its judgment. But the more direct point, I think, is that in terms of the real points that were made against the appellant and the basis on which this case was decided against him, Maître Moutia's apparently quite careful degree of involvement hadn't gone to the essential problem, which was that the originating process was and remained non-compliant.
Well, he wasn't taking responsibility for anything. Yeah.
No, Lord, no. That's the conclusion to which one's drawn. And for what it's worth, it seems to be confirmed by what Mr. Hurnam said at the hearing. No attorney's willing to sign the document. So, my Lord, although it's fair to say that argument was addressed by Mr. Hurnam at the hearing and wasn't referred to by the court in our submission, there was nonetheless an inevitable answer to it. If that's right, my Lords, then there may be a question as to precisely what was the source of this residual discretion that was referred to by the full bench, and essentially that part of the reasoning obviously followed in the present case. And I think my Lords have my submissions on that. It may or may not be entirely felicitous to call it a discretion, but it stems from the inherent jurisdiction of the court to control its own procedures. And my Lords, I'm not sure I need to take you to it, but we've put in, and we hope it's convenient, a section from Volume 2 of the White Book, which simply collates some notes in relation to that territory. It's 9A 68 in particular, which is, and again, I'm afraid it's loose.
Possibly more to the point was the authority to which Mr. Hurnam so helpfully referred us to, Kennel against Dorel, that old case.
Absolutely, my Lord, yes. Yes.
So what's the White Book passage look like there?
It's in Volume 2, 9A 68. It follows on from Section 19 of the Senior Courts Act 1981, dealing with the general jurisdiction of the High Court, and we've seen the coordinates of that in the Courts Act in this case.
So,
and in 9A68, there's a collection of some well-known, I think, citations from the cases as to the inherent jurisdiction, and in particular, possibly the fourth paragraph. Powers said to be inherent in the High Court's jurisdiction can't be stated succinctly. Said by the highest authority, there can be no doubt that a court which is endowed with a particular jurisdiction has powers which are necessary to enable it to act effectively within such jurisdiction, and that a court must enjoy such powers in order to enforce its rules of practice and to suppress any abuse of its process and defeat any attempted thwarting of its processes.
well, wait a minute. What about the case of Tombstone Limited against Raja, top of the next page, where the Court of Appeal apparently stated that the position pre-CPR and since was that the inherent powers of the court could not be invoked to do something which was inconsistent with a rule.
Yes.
Where the matter is governed by a rule, it should be dealt with in accordance with the rules. Well, is that right?
Well, my lord, even assuming it is, in my submission, what the conclusions of the courts in Mauritius in relation to these issues wouldn't defend against such a principle, because, as we point out in our printed case, Rule 3.3 doesn't specify any automatic or particular sanction for non-compliance. One sees it as a mandatory requirement, but there's nothing that says in the event of non-compliance, X will follow.
And they're making sense of Rule 3 of the cost rules.
Yes.
Well, I suppose Rule 3 of the cost rules, insofar as it's necessary to apply it to claimants, it could just apply to defendants, as we put before.
Well, my lord, it could, and there are at least one. There's at least one other point in relation to Rule 3 of the cost rules, which is that if one looks at those rules, one sees that they are made to apply compendiously to the Supreme Court and also to the lower courts, the Intermediate Court and the District Court.
I see, yes, yes.
And the rules of those courts are different, and on the face of it, don't require a party to have an attorney, and there's no comparable provision to Rule 3.3 or Rule 5.2.
Right.
So it may be said that where it refers to or the party, because it's all been tied up compendiously, that could be contemplating a party to proceedings in the lower courts who may not have an attorney.
Yeah, I'm with you.
And
Very
or
helpful, yeah.
and or a defendant, and or perhaps a plaintiff, but who has been permitted to proceed for some good reason without an attorney.
Well, that's certainly your case.
Yes.
Right?
My lords, just before I leave this topic, can I just show you one authority which I think supports what I've said about the territory that we're in and the source of this discretion, which is that we may well be in the territory of the court's appropriate responses to what may be an abuse of the process. And of course, the court, if there's an abuse, the court doesn't have to stay the proceedings or set it aside. It simply can do on appropriate facts. But the case is Tranche and Ramlagan, which is tab 11, R11. MS 473, a case from 1954. My lords, this was an appeal to the Supreme Court, so sitting in its appellate jurisdiction. And one sees from the opening paragraphs that a number of potential defects of procedure were identified in the appeal. And picking it up, particularly the third paragraph on the first page of this decision, a fourth defect in the procedure was that the appellant had, contrary to Rule 60 of the RSC, without leave of the court, signed the notice of appeal himself, instead of its being signed by an attorney. And then one sees from the following paragraph, when the case came before the court, the appellant prayed for leave to appear in person. Application refused, but as he was found to be a poor person, he was assigned counsel and attorney, who then thenceforth conducted the proceedings for him. And so the question then arises whether those irregularities debar him from proceeding with his appeal. And my lords, the Supreme Court then dealt with the other defects which aren't relevant for our purposes, but taking it over to the pre-penultimate paragraph on the following page, one sees the paragraph starting the fourth objection. So the fourth objection to the hearing is regarded by counsel for the appellant, so that's, I think, the counsel we've just seen referred to, as a more serious one. Mr. Vonchard submitted that signing the notice of appeal without the leave of the court constituted an abuse of the process. The more so, the appellant infringed the rules of the court, not through ignorance, but presumably deliberately. And there's reference to his having been previously, as we're having fallen foul of the same rule.
You've made your submissions on Mr. Hurnam's failure to put any case properly about exceptional circumstances. He's intimated to us that his case would be that he can't find any attorney on the island to put his name to the sort of actions that he's been instituting. Do you want to make it all perhaps to the side, but do you want to make any submissions as to whether that would be a ground for saying there are no exceptional circumstances here? Or would it be more a ground for looking at the actions and seeing whether they were an abuse of process, Mr. Casey?
Well, my lord, if the evidence were, or if there were evidence, that I've approached 10 attorneys and I've shown them the originating process that I want them to come in and take over, and they've all said, no, I'm not prepared to do it, then one might need to know why they're not prepared to do it. If they're saying, I'm not prepared to do it because I take the view that this action can't correctly and conscientiously be advanced, then in my submission, what one sees really is the rule working as it should. If they're saying, or if one infers, I'm not prepared to lend my name to it because I'm concerned for my own advancement, I don't want to be seen to be helping you in a case against serving members of the judiciary, then if the action had potential merit, I can see that might well amount to a good reason for non-compliance with the rule. If one has a case which is politically sensitive, and if the court concludes that the reason no attorney, and as it were, attempts having been made, the reason no attorney will come in and adopt it is because of political sensitivity as opposed to out of professional compunction, then that might well be a good reason. But that's quite a substantial piece of evidence to construct.
Quite difficult. There's all sorts of privilege issues, aren't there?
Yes.
I should have thought it extremely difficult to get attorneys to come forward and say that they didn't want to take proceedings because of the personality of the proposed defendant. But surely if Mr. Hurnam can come before the court and say, look, I've tried many attorneys, all of them steadfastly refuse. Here is my case. It isn't obviously vexatious, and invites the court then to say, well, these are exceptional circumstances. In other words, he's saying, well, why should I be denied access to the court simply because attorneys, for whatever reason, refuse to undertake my case? It would be very difficult for a court in those circumstances to say these are not exceptional circumstances.
Well, my lord, I take that point. I think that must be right. Subject to that then engaging something that hasn't happened in this case yet, which is the court considering whether or not the proceedings are, or are in certain respects, obviously vexatious or scandalous or an abuse.
That's why Lord Wilson's two questions prove to be inseparable, don't they? I mean,
Yes.
you can only really answer practically the first by reference to the second.
Yes.
So,
Thank you.
what do we make of the present court's decisions then, if we pursue this line on this subject? I mean, the 1st of July, the full court simply says no exceptional circumstances shown, without, as far as one can see, expressing any view on the tenability of the litigation. It was presumably told that he couldn't get anyone else. Certainly this court, the present court, was told that. Well,
my lord, in my submission, the position is this, that Mr. Hurnam did not advance a sufficiently evidentially founded case to bring him to, as it were, where this debate presupposes a litigant might bring himself. Although I take my lord's point that attorneys who are turning down cases for those sorts of reasons may well be unlikely to say so. Equally, attorneys who are turning down cases genuinely because they take the view that the case can't conscientiously be advanced might well say so. What we don't know in this case is whether or not, in fact, Mr. Hurnam did approach attorneys other than Maître Moutia and was turned down, and whether or not Maître Moutia said, well, I'm prepared to act for you in certain respects, but I'm not prepared to lend my name to the document. And in my submission, it's incumbent on a litigant in Mr. Hurnam's position to descend to that sort of level of particularity if he's seeking to be excused from compliance with the rules.
Yes, I mean, he says he's got an arguable case. That hasn't been examined, but if he has an arguable case, one would expect him, to put it to a number of attorneys, you say, and then if he surprisingly gets a refusal, to put that before the court.
Yes. But aside from the comments that one saw in the transcript, no attorney, my lords, I'll look at it because one needs to get it right perhaps for the purposes of this debate. I think he says at page 88 of the record, at the foot of the page, and say I want to enter proceedings because of such reasons, I cannot do so. No attorney is willing to sign my documents because of the averments which are against the judge.
Well, that's an assertion of something which there wasn't, you say, hasn't been made good, perhaps?
My lord, in my submission, it hasn't been made good. There are two possibilities. Either he has concluded that it sort of goes without saying that no attorney would sign the document because of the explosive nature of the allegations made, and that, in my submission, wouldn't be good enough. Or he might be saying, I have tried to enlist the help of an attorney and have been turned down.
Well, the court was certainly put on notice by Mr. Hurnam's statement that he couldn't get an attorney because he was taking proceedings against the judge. Now, if in those circumstances the court considered that that simple, unvarnished, unsupported statement was not enough to trigger its consideration of whether there were exceptional circumstances, one would have thought that the court would have said so.
Well, my lord, I see that point. What one can say is that the conclusion of the hearing, as it were, it seems that at the conclusion of the hearing, either Mr. Hurnam had said all that he could say and had essentially made his case on exceptional circumstances, and then it was a matter for the court to decide whether that was sufficient, or it was left on the footing that he might come back to court to try and make such a case.
Well, did the court ever make that point to him?
No. No, my lord, no.
I mean, he was never given any reason to suppose that the court had decided not to accept his statement as to the reason that he wasn't represented by an attorney.
My lord, that's certainly fair. He wasn't told, as it were, well, we've listened to what you say, and you should know that our view is that's not good enough.
Yeah. Well, if that was indeed their view, did they ever say that exceptional circumstances don't arise in this case?
Well, my lord, all they said in the judgment at page 116 of the record, para 6,
They say the facts were identical with the prior case, but is that absolutely right? I mean, the prior case was presumably about something different.
yes, it certainly wasn't. I think when they say the facts, they can't mean the nature of the underlying claims, because they're different claims. And they say that the court, I think in the full bench hearing, after having examined the motion paper, found the applicant to show no exceptional circumstances to justify his decision to dispense with the services of an attorney. Indeed, the applicant has simply declined to have recourse to an attorney for his action, which he has signed himself.
Yes, but that's...
So, my lord, that's all they say about it.
I mean, that's a slightly... that's a different point, because on one view of 100 and 101, he was saying, well, if I'm wrong about that stance, then... So what would... I mean, if we really were to pursue that point and to conclude that something may have gone wrong there, or had gone wrong, what should we do?
Well, my lord, if the board's conclusion is that something has gone wrong in that respect, then the appropriate disposal, I think, must be to remit that question to the Supreme Court, for the Supreme Court to consider what further material might be adduced by Mr. Hurnam on the question of, as it were, the reasons for his non-compliance at the outset with the rules.
Can we just see what the supporting material was for the proposition that the reluctance of attorneys to adopt the proceedings related to the identity of some of the defendants as judges. Is page 1 of the record the action, as it were?
Yes, my lord. This is the this is what's described as the motion
No, it's described
paper.
as a motion. I'm not
Yes.
at the moment worried about
It is, my lord,
that's
yes.
accurate or not, but this is the claim.
Yes.
Well, it's a claim, if I read it rightly, principally for an order that the professional disciplinary proceedings be reopened.
Yes.
And all the addition of all the various judges looks, unless I've misunderstood it, which is quite possible, really to be entirely ancillary. The only relief that's claimed, or the real relief, principal relief that's claimed, is in order to reopen the disciplinary proceedings, and that on grounds that there is some kind of fresh evidence which undermines the original conviction.
My lord, that
None of which puts the conduct of the judges in issue at all.
My lord, that doesn't, and it's certainly our apprehension that that's the principal relief which is sought, although one notes that Order H seeks redress in the sum of 200 million rupees. But my lord, I suspect that when Mr. Hurnam referred to allegations against judges, he may have been referring to paragraph B, in fairness to him, on page 2.
Yes.
Yeah, it's
Yes, I'm sure he is.
B and C, isn't it?
I'm sure he is. But those only get off the ground if there's an arguable case on A.
Yes.
Okay.
And it's hard to see how substantively they take the matter further.
I take the point that, as Lord Rogers said in the earlier judgment, that there isn't an equivalent of Section 74 of whichever act it is, which makes the conviction evidence of its of the commission of the offence. But unless the disciplinary code is very unusual, the mere commission, the mere fact of conviction, is likely to be a pretty powerful ground for disbarment, isn't it? You can't query the facts underlying.
That, I think until the rules were amended governing solicitors in this jurisdiction, it used to be possible to argue that the charge had to be proved all over again.
Did it?
Yes.
I see.
On the basis that a conviction in another court is just somebody else's view.
Yes.
So I think you need a specific provision,
Well, my lord,
probably.
Anyway,
I mean, I'm not prejudging.
that all goes to the merits.
yes.
But
I thought into Hollington and Hawthorne territory.
Yes.
yeah,
But my lord's right. If one, no doubt, if one put these proceedings before an attorney and said, "Please adopt this for me and act for me in this case," an attorney might well say, taking a more nuanced approach, "Well, I can see how if we limit ourselves to Order A and perhaps the application for interim relief reinstating you in the meantime." Then fine, but I don't really see why you need B and what B adds to A, and B appears to be a bit scandalous.
The trouble is that it may not be necessary, but it's certainly perhaps all the more striking
part of it. Okay.
if it's unnecessary.
My lords,
The lawyer is being asked to endorse something which,
yes,
on any view, necessary or not, and perhaps even more if it's unnecessary, is controversial.
yes,
Yes.
absolutely, my lord, and I see there's a difference between controversy and impropriety.
Yeah.
But lawyers, particularly in a small jurisdiction, may be reluctant to get into the former as well as the latter territory. My main point, my lords, is that by the time the January 2012 hearing came around, Mr. Hurnam knew that this was well and truly what the focus of the case was about. The full bench decision had now been promulgated. The hearing was to consider solely the question of whether he should be excused compliance or not with the rules. And the material which he put before the court was exiguous at best in the form of what he said that no attorney is willing to sign. And it was incumbent on him, if he wished to make this case, to have some better evidence before the court knowing full well that this was going to be the centre of the hearing. Question of interpretation of the rules, and if he was wrong about that, what the court should do about it. And in my submission, we know that he then revisited the court about a month later and didn't take the opportunity then to put in a clear case on the point. And in my submission, it would be wrong now for him to be enabled to extend the process by clutching at this straw before the board.
Right.
My Lords, I see the time. Subject to my Lords, then, it seems to me the logical next area for my submissions would be the constitutional arguments. But
well, I don't think Mr. Hurnam pursued that after mentioning it once. We pointed out that it wasn't raised below, but yes, well, I think you better deal with it briefly. Mr. Hurnam can reply then.
My Lord, absolutely. Perhaps I can keep it at this level. We say that we submit that this is very clearly a case where if these arguments were to be ventilated before the board, they should have been taken below. Whether one takes it at the level of inconsistency of the rules themselves with the Constitution, and I agree with my learned friends that would be an unlikely conclusion in this case, given the fact that legal aid is available, that there is a residual discretion, if one calls it that, and so on. It would be surprising to conclude that there's inconsistency at that level, or whether one says that the application of the rules in Mr. Hurnam's case has led to some infringement of his constitutional rights, which essentially engages the same questions in the submission. Has the very essence of the right been impaired, and so on. Then
I think your strongest point is surely that a decision on this question must reflect and embrace a knowledge of local conditions.
Absolutely, my Lord.
And it would be wrong for the board to make assumptions about what local conditions, what answer they would impel.
My Lord, precisely, and particularly when one knows and the board knows that there's reason to believe there are problems in Mauritius with availability of judicial resources and hence some problems of endemic delay. So particularly.
I mean, your second point is surely unnecessary, because if there's nothing wrong with the rules, but the way they were applied infringed the Constitution, then it certainly also infringed ordinary principles of justice, which
yes.
are inherent in the rules.
Yes.
I thought. Right. So, but anyway, yeah. You say that the main point is one which should have been constituted before, and I no doubt you would say that there's plenty of justification for this type of provision, which one finds certainly one found under Rule 60,
yes,
and one finds in lots of civil law countries.
Lord, yes, and my Lord, we would echo the way my Lord put the significance in this respect of the Code de procédure civile, although we don't rely on it, and the courts below didn't advert to it. It is perhaps relevant as a matter of background culture that one sees that there have been from early times requirements under the French civil law system for parties to have avoué. And we have included in our supplemental bundle some doctrine which explains the reason for that, and it's essentially if I can summarize, to ensure the smooth and proper administration of justice. My Lord, we've got the reference in our note on the Code de procédure civile for that.
It is rather odd that the removal of Rule 60 gives defendants greater rights, because there's no restriction now, except I suppose that before the Supreme Court they must be represented, must they? Unless they get the court's consent.
Yes.
But anyway, it gives them greater rights as regards pursuit of their defence, although one can understand why they should have that. But it actually gives claimants on the face of the rules lesser rights, although you redress that by the discretion argument.
Yes, on the face of it, as it were, it's harder to find the avenue by reference to which a plaintiff can come to court and say, please allow me to rely upon this originating process, for example, despite the fact that I issued as a litigant in person. It may be the answer is, well, unless and until the point is taken against him, then the plaintiff simply carries on, and that's what Mr. Hurnam appears to have done in a number of cases.
The other thing, of course, is that the issue of process by a plaintiff is voluntary, but the response to it by a defendant is not.
Oh, yes. And that's why we say there's obviously a rational distinction to be made between the two categories of litigant. And to that extent, the 2000 rules do appear to represent what Mr. Hurnam described as a liberalisation of the position. Defendants are no longer prima facie obliged to file their defence through an attorney. But it's quite clear that those requirements have survived in relation to plaintiffs.
I mean, slightly, the Court of Appeal, sorry, the full court's approach to Rule 60 was a bit odd because they seemed to treat it as if it allowed representation pro se, in person. But it never did, because it was only on sufficient cause shown that you were allowed to sue or defend in your own name.
Yes.
So anyway, that's the truth is, as regards claimants, the position before with Rule 60 and after without it is roughly the same.
Yes. That's our position, Lord, yes.
Right.
My Lords, I see the time. I think I've, I hope, appropriately focused my fire. And I know that my Lords want to hear from the amici.
If only to show how grateful we are that they've been willing to.
Oh, we definitely want for other reasons as well.
That was not intended to diminish their submissions.
Oh, we have lots of questions for you, Mike.
Right, well, thank you very much indeed, Mr. Casey. Yes, Mr.
I'm not sure that
McColgan, yes, and that wasn't intended to restrict you, but just as a joke.
in that spirit, but I'm not sure that there's much I need to add to the written submissions. And it seems to me there were 3 potential points where there was at least a possibility of a constitutional argument getting home with the assistance of Article 6 of the Convention, but as we've explored in the written submissions, both in terms of access to the court and equality of arms, if one takes into account the jurisprudence arising under Article 6, it doesn't truly assist the appellant.
Yes, that, if I may say so, was a very helpful part of your case, and puts it in a wider context.
It would be quite surprising, actually, if
In Strasbourg, they had
reached a different conclusion, bearing in mind
their client states.
Yes, indeed. And we looked also at the issue of delay. Now, I have not yet seen the clarification of the 8th of June, so I'm not clear whether there is...
It's not in
whether there is room for discussion about the 25-month delay between...
Can you be shown that?
It's a matter for your lordships whether delay is even something you want to be addressed about. Thank you.
I think the view we're taking is that we don't need to be addressed on that, because on the face of it, I mean, we would be acting as a first instance court, and without the benefit of the courts below, and if there's a remedy, it's a remedy which presumably exists at least at first instance, if not in the Court of Appeal itself.
Indeed. Well,
I mean, I suppose at first instance, actually.
That being the case, unless there's any questions you want to raise with me, I've nothing additional.
I suppose, I mean, the oddity about all this is that one had what seemed to be a fairly clear pattern in the previous rules, whereby you have the restriction on serving proceedings without an advocate, and then you have Rule 60, which makes it clear what the court's powers are. And then you get rid of, for some reason, you get rid of Article 60, and you have to then rely on some sort of inherent jurisdiction. Do you have any sort of explanation of why that change
I
was
certainly
made.
have no explanation. I thought when we were looking at how we could assist the court, we took the view that the best thing to do was to look at the constitutional questions. So I'm afraid I'm not an expert on the...
No, well, I understand that. I just thought I would just raise it with you.
No, I mean,
I'm reminded there are no explanatory notes, certainly, that we've been able to...
well, that's very helpful. And I imagine that if there had been explanatory material, Mr. Hurnam or Mr. Casey would have produced something. Yes, it just happens that way. Yeah.
Well, now, Lord Kerr had a lot of questions.
No, I have none that I want to utter at the moment.
Thank you very much indeed. Yes, Mr.
Well, my lords, I have listened to the submissions made on behalf of the respondents, and of course, at one point in time, the lordship queried whether the mere fact of a conviction is prima facie evidence. But this is not in our law. In our law, in the Law Practitioners Act, a mere conviction is not...
I accept that, Mr. Hurnam. You needn't go any further. In fact, that wasn't the proposition. It was that the conviction might itself be misconduct, but that's a different question, and it doesn't arise. So we'll leave it alone.
Yes.
I think we'll proceed on the basis that it's open to you to
the lordship's
challenge
right.
a conviction in disciplinary proceedings.
As you're right, lordship.
Or indeed, simply to say it doesn't have evidential value.
Yeah.
That's correct. But the board ruled on it, and I was prevented from it.
As I say, it was the old common law, as I recall.
Yes. But then, and your lordship also stated rightly so, when you look at the motion paper and the affidavit there too, in support of my motion, there's nothing which is abusive or vexatious in that motion paper. It's Order A to reopen disciplinary proceedings.
Well, there is a slightly different point, and you mustn't take us necessarily as addressing that.
Yes.
We haven't investigated in Mauritian
Yes.
practice, but there is a general power inherent in the court's jurisdiction to strike out litigation which is abusive, and
That's right.
relitigating matters can be abusive, even though there's not a formal legal bar by way of res judicata or estoppel or evidential bar. That's a delicate area which may or may not apply here, but it's just one which I make sure we're not opining on.
Even on the basis of fresh evidence available, my lords?
Well, of course, that's, again, a different ballgame.
Yes. So I would say that none of these orders prayed for can be cited as being abusive or vexatious.
Yes.
So,
Well, you're not really concerned with that.
yeah, nobody answering there? Yes. Okay. The other issue is, as I made it clear, my lord, right from day one before the court on the 30th of May. Can we look at the proceedings of the 30th of May 2011? The proceedings as they appear in, yes.
Page?
It's page 34. Page 34 of the record, and it goes on from 30, more precisely.
That's 20th of June, isn't it, Mr. Hurnam?
Sorry, my lord, 34 is the 20th of June, yes, sorry, 20th of June. But then it released the motion paper, which was signed by myself.
Right.
On the 30th of May 2011, returnable on Monday, page 4, returnable on Monday 20th of June. Is that okay, my lord? The proceedings.
Sorry, where?
The notice of motion, take note of the above named applicant, shall on Monday 20th June,
Which page are you on now?
page 4 of the proceedings.
Ah, yes. Yes.
The motion itself was signed on the 30th, was reasonable the 20th of June. Now, as we go along, and you see the 20th of June is at page, the proceedings of 20th of June is at page 34. So you would note that as at 20th of June, there was the full bench judgment of the 1st of July was not out yet.
Right.
And of course, there were objections to me putting in that motion paper because the judgment was awaited. And eventually, your lordship will note that at page 40, sorry. Then they came before where the court decided on its own motion to suggest to me. And that would be on the 20th of July. The proceedings of 20th of July, at pages 54 onwards, and more precisely,
Right.
at page 58, my lord, at line 10. You still have not answered my question, says the court. What I'm asking you is that if you are interested in having this issue of disciplinary proceedings dealt with, if you're minded to have an attorney.
Yeah.
But of course, if you want to go through the whole procedure, you may appeal to the Privy Council. That is entirely your right. But I'm not quite. So it's the court, on its own volition, decided whether I would need an attorney.
Yes.
And at some point in time, I said, of course, allow me to adduce evidence. But the court was not properly constituted. That court was a single bench. Yes. So I couldn't give any evidence yet because it was it was just before the judgment.
Right.
The court was not properly constituted, my lords. If your lordship will look at the initial proceedings at page 34 or the 20th of June, court observes, 20th of June, my lords, page 34. Court observed the matter was previously scheduled before Honourable A. Konai, judge, and herself. But in view of a letter which has been received from the applicant this morning, and in view of the contents to him, is what I have thought appropriate not to form part of the bench. So, on the 20th, when the court, so that when we go back to this page, where the court was still sitting alone, 20th of, and I said I have anticipated the question, 58, my lords. Line 15, as I said, if properly constituted court will rule me out, that henceforth can only mean you desire to have a ruling. So what I will do is I'm going to have the matter mentioned, line 20, page 58.
Yes.
Before the master on the 8th of September for the matter to be fixed for appropriate bench. So I had put myself in the shoes of the court, in the shoes of the ruling. As I said, if the court has allowed this, I'm not foreign to this idea. My notice is already prepared by an attorney. So there was advance notice of my attorney stepping in, following the suggestion of the court.
Yes, well, I know the difficulty is the way you actually followed the suggestion may be questionable. So we're looking at that, aren't we?
But my lord, let us put it this way.
Let us what?
As I said, at the risk of repeating myself, when Mr. Mucha enters with a notice, all right, I follow the submissions, but then in our small jurisdiction like Mauritius, or like anybody else, I suppose, applicants or any person can draw up his own affidavit. He draws up his own affidavit, he signs it, he affirms it before a judicial officer or a law officer or a officer of the court. There's no need to sign that affidavit by the attorney. He can draw up. In a small jurisdiction like Mauritius, once the affidavit, which is a backbone of the motion paper itself, is admitted as evidence, the rest of Mr. Mucha's certifying that I drew up the motion, he looked at the original and compared
He didn't certify, well, he certified that you had drawn it up, which is not what an advocate's certificate is about at all, is it?
That was
Just show us the Mucha documents.
63.
63, thank you very much.
Yes, 63, my lord. Yes, 63, 64, 62, 63, yes. But as your lordship rightly pointed out, take notice that following the judgment of the full bench of the Supreme Court delivered on 1st of July in the matter, and without prejudice to the application for special leave lodged with the Judicial Committee of the Privy Council on 8th of July, I'm hence...
We've read it and we know what it says, and it does say I'm henceforth instructed to appear, which looks rather promising. But then, when it comes to the question of process,
yes,
it's all it says is I've certified the motion paper, notice of motion and affidavit attached thereto as being true copies of the originals, and that's, he then certifies the whole document and certifies it as a copy, and the originals he certifies as a copy only. So that's not action, professional activity at all in relation to the notice of motion and affidavit.
Well, in which case, my lord, I suggest that when we go deeper into the issues, I will be repeating myself. You would note that I had two motions. One, if I'm allowed to adduce evidence on motion 4, on the issue of exceptional circumstances or good. Sorry?
Where is that motion?
Yes.
You've got no formal motion to that effect, have you?
Yes. Well, I have two motions, as I said.
You possibly made some oral submissions about
That's right.
it. We've looked at them several times.
My lord, at page 79 over there,
Yes, correct.
of the 30th of January 2012.
Yes.
Yes. My lords, with leave of the court, I move to appear in person. Before the court proceeds, I'm proposing to adduce evidence on a matter, but that was in relation to the Privy Council appeal.
Yes.
So the court said, don't worry about that.
No.
Do not. And then subsequently, your lordship will note that after arguments were offered, the special circumstances, as I said, we at page 89, sorry, at page 88 first, my lord, line 15. No. The question I mean for both sides, for the respondents as well and for the applicant now. When the bench says, when the full bench says, we do have notice that notwithstanding the change in the rules affected by the Supreme Court rule, actions initiated by litigants have on several occasions been entertained without exceptional circumstances. Now, where do we get these terms from exceptional? That's the court asking me. Well, there is none. Your Lordship,
I can see that.
Yes.
They're certainly asking you,
where?
What's the legal basis? Yeah.
Yeah, from in the judgment. The judgment is silent on it altogether. This is what I've been saying all the time to the court below. That if the court had come up to say in this judgment of the 1st of July, what exceptional circumstances, then by all means I could come up with those evidence and put them in. But, well, sorry, okay, we'll listen to you later on this point. And then, Your Lordship, at page 89, line 10, would you accept this service? I wanted to give some evidence on this. Eventually, I will move to give evidence on my submission if the court will allow me to say about these exceptional circumstances and then the rest of it. But if Your Lordship will look at this, again, the court says no. Somewhere they come to say, don't worry about that. We don't need you at this point in time.
Where are they saying that?
At page 92, my lords.
92, yes.
92. Court, and then at line 5. I was already prepared for that in order not to unduly protect this matter. But, my lords, it is a matter which is very important. It is a matter which is really fundamental, and therefore it would be my submission that the court hears me. Line 6, 7, my lords. Or alternatively, allow the matter to proceed as there is no legal impediment that there is any effect or any defect. Probably there is a misprint. The defect has been cured. This was my statement to the. Your Lordship must be aware of the famous case in bail application or in matters of fundamental breach of the Constitution, that procedural factors should not be placed in the way of such breaches. So I did take the issue of sort of fundamental breach.
This passage is not dealing with exceptional circumstances, is it? It's dealing with the basic point about an advocate,
No, my lord.
attorney, isn't it?
No, this is dealing with my basic proposition that would you hear me on my special circumstances?
I see.
And then I say, you see a line 13.
Well, this is a continuation of the passage starting at page 90, line 10, the second issue, which is precisely the one which is more pertinent, is whether the subsequent certifying that the motion paper, etc., by an attorney who's been duly retained would justify this action to be proceeded.
Yes.
And then you go on addressing that, and that's all the way down to 92, and that's the point you're dealing with there.
But this is where I say, would you hear me?
Yes, you said, will you hear me? And that's but it's all on a point which we're not concerned with at the moment.
But
I thought you were addressing exceptional circumstances. The best passages, it seems to me at present, on exceptional circumstances, or the relevant passages, are later.
Yes, but I said I had two motions, my lord.
Yeah, right.
And I said at page 93:15.
Okay.
And finally, as your lordship earlier stated, at page 94. No, I'm not. But I'm saying you are about. It's inaudible about this exceptional circumstances. I made my point. Can I wind up my submission? Is that it is regular to proceed in view of the word henceforth? And finally, at 94, line 30, the second aspect is that applicant is matter be allowed to give evidence why he needs to bring facts that such discretion of the court be exercised in his favor to continue with this case. So this is it's a motion made to the court, but the court says just wait for that moment. That's your third point. In that case, this attorney was subsequently retained. So if the attorney was subsequently retained, whether he did not cure the defect. So that's the court asking me questions about that. And finally, my lord, the submission of Mrs. Pun. She said that there was no need to hear me because there's already an attorney in the matter, and therefore we were in a fix. I still insist before the court at page 100, where she says, therefore the request made by the applicant to have him heard on the evidence as regards exceptions at the top of the page, my lord. Therefore, the request made by the applicant to have him heard on the evidence as regards exceptional circumstances that he should be allowed to proceed are not applicable in the present case because he wishes to have been represented by Mr. Attorney. So she rests her submission on that.
Yeah.
So I was shut out from giving this evidence altogether. And she objected to that. Now the court, well, I said in a short reply, yes, I think we went over that, my lord, earlier. And line 25, that is what I said. Without any prejudice to the matter pending, I'm saying whether I could first proceed with my motion paper signed by me, affidavit and all. Can I proceed on that? But before I do, I proceed. Can the court hear me on the exceptional circumstances? I cannot invoke a spent rule to come before the court and say, give me leave. How would I come before this court and ask for leave? The respondent say, where is leave obtained first? But the provision has been spent. So I can only come, last but one line, I can only come to the court by substantive motion, explain to the court why I could not render the services of an attorney at the time when the papers were issued. Well, the respondent replied that Mr. Attorney came over. Mr. Attorney Mucha came. So at the time of the institution of the process and issue and service on the defendants or the respondents, I could not get somebody. But then my last observation, line 5 to onwards.
What do you mean by pre-innate?
The third, yes.
In the second line on page 101, what did you mean? I mean, do you mean revive? What does it mean?
Which one? Yes.
Second line, page 101. It is impensable.
C'est impensable.
Impensable.
Impensable means unthinkable.
Yes, quite. I think we understand.
Well, as I said, the observation...
I must pre-innate Rule 60 of the spent rules.
Reinvent, bring it back. Mr. Mucha's intervention has cured the defect, if any. I did not hear anything whether henceforth...
Okay, bring it back. Okay, revive.
I revived it, my lord.
Yes. All right. So, in fact, what you're saying is that there's no basis on which you could have applied for exceptional circumstances. You're not saying you want to, you're saying it's inconceivable that there's any basis for doing so because on the respondent's submission,
That's right. I mean,
the rules constitute an absolute prohibition on personal appearance. But then I suppose one must read further. What's the next paragraph mean?
well, my lord,
Last observation is the certification by Mr. Mutia.
that's right.
As I said, first allow me here evidence on whatever circumstances. The court says no, then the next issue as an alternative measure without any prejudice to my earlier motion.
That's right. Yeah,
That mean?
but your lordship will read. We take it back from page 100 at the top, where was. But then the court says okay, and then all right, thank you, thank you for your submissions. Ruling is reserved. Now the respondent made the point that I moved the court on page 102 in terms of a letter regarding interim relief. This is page 102. In support thereof, I put in certain documents, and the proceedings are found at page 105. Sorry, not 105. The proceedings are found.
Well, we know what they're about. 103
Yes.
tells us, yes.
At 103.
Yeah.
Without prejudice to the merits of the application and etc. But nothing was. My attorney was still alive there. He was still acting for me. All right. The board say that, or the court say that Rule 3 is mandatory for proceedings to be initiated. I still go back to my it cannot be mandatory. It is not mandatory. It is directory. Now, therefore, in such a case, if discretion can be allowed in such a case, the present one, where and how would the court exercise discretion, on what basis? Here you are, for the past 15 years, you've been allowing litigant. It's only me, my lord. Nobody else in Mauritius, except probably one more counsel, one more barrister, who had one case only. And then suddenly you come out and say, no, come on, you can't do that. But now, allow me, post the judgment, to bring in some evidence. But what is exceptional circumstances? It hasn't been said so. And the respondents have come up with a judgment, my lord. I think it is. Sorry, before I go on to that, your lordships did question about appellate divisions. At page 281 of my electronic copy, but of course it's tab 1, tab 2, tab 3, tab 4. You would
Volume 1 or Volume 2?
Volume 2.
Very well. Thank you.
Yes. Your lordship would note at tab 3, tab 4. Let us look at tab 3, my lord. Rules made by the Chief Justice, section 198.
Sorry, wait a minute. Tab 3
tab
or
3.
4 of what?
Oh, volume 2.
Well, I was looking at volume 2.
No, that's when you lost your appeal. That's when the...
Volume 1, he means.
He means Volume 1.
Yeah, the rules, yes.
Yes.
So what are we looking at?
Well, Rule 2. In any action before the Supreme Court or before any of its division, the attorney or party initiating the action shall be responsible for providing to the court and to the attorney or any other party to the action, and in the case of any other party not legally represented, to the party himself, an indexed copy of all documents and records for the proceedings of the court. So the defendant appears in person.
Yes.
So this is not the only rule we have as far as we are concerned. If your lordship will go on the next page, sorry, the next tab.
Right.
Sorry, one before, my lord. At page, yes, GN 203 of 2002. This is tab 1. Tab 3. I have put them together.
Mr. Hurnam, it's
Yes,
my
my lord.
fault. I'm lost.
Sorry.
I think you've taken us to 3 different tabs.
This is a reply, I think, isn't it?
Yes, well,
You seem to be stretching rather into...
Lordship's set a question whether defendants on appeal are treated in the same manner as defendants in the trial court.
Yes.
So this tab is in relation to, my answer is in relation to that. Now, the other matter which was led to was about, this is at tab 6, the French Code de procédure civile, which was submitted by the respondent.
Yeah.
L'exploit d'ajournement contiendra la date, les jours, mois et ans, les noms, professions et domicile du demandeur, la constitution de l'avoué qui occupera pour lui et chez lequel l'élection de domicile sera de droit, à moins d'une élection contraire par le même. Now, then thing goes on, my lord. Les noms, demeures, etc. But this is not available in our law. Alinéa 2 is not available.
Well, a huissier is not available.
Yes. The usher who...
I'm not sure what the status of this document is anyway.
It's part of the Article 61 of the Code de procédure civile to which the respondent...
No.
Respondent...
This doesn't apply. It's superseded by the rules.
Doesn't apply to Mauritius.
This is the old law. It may be that it wasn't very apt because there weren't huissier, but it does indicate that under the old law you had to have an avoué to start proceedings, doesn't it?
Yes, because they are in conflict with the local rules. And when they are in conflict, our rules having been given statutory authority by enactments, these do not apply.
Right, what other points have you got to make by reply?
Yes. Well, I suggest in the event that the board decides to remit the matter to the court below, to the Supreme Court, I would suggest if the matter be sent to deal, can direction be given to deal with it DNDM, please, to hear it as soon as possible in view of the delay, if at all the board decides to do that.
Right, yes. As early a hearing as possible, yes. Right.
Thank you, my lords. Anything, if your lordship would need me to say?
Thank you very much indeed. Well, the board is grateful for the assistance which it's received from all sides and will take time to consider its judgment.